Many people are interested in family visits, but don't want to abandon their life in their country for one here in the United States. If your parents want to settle in America, they need to consider how much time they must live in the US to keep their green card. A green card is not just an easy travel pass, because if they stay outside the US for over 100 days, they can lose the green card. I know it happened to my family. Many parents agree to come to the US to help their other kids get green cards despite objections to the process. Just be sure they understand the commitments first. Hi, I'm Andre Mejer, immigration attorney and an immigrant myself. And today we'll cover how to petition for your parents. If you think this kind of video is helpful, please consider subscribing to my channel and checking out my other videos. Let's get into it. Who qualifies to petition for their parents? To petition to get a green card for your parents, you must meet several basic requirements. One, you must be a U.S. citizen. Lawful permanent resident is not enough. You must be a citizen in order to file an immigration petition on your parents' behalf. Now, you're a citizen of the United States if you're naturalized after you applied and passed the exam, or you were born in the United States or its territories, including U.S. Virgin Islands, Puerto Rico, or Guam, or you're born outside the U.S. or its territories, and you acquired U.S. citizenship because one of your parents was a U.S. citizen when you were born. Or you're born outside the United States, you derived United citizenship when your parents, whom you lived with, naturalized before you turned 18. If you are unsure of any of these, leave a comment below, give us a call, or visit our website on thismecherlaw.com, and we'll get back to you. Second, you must be at least 21 years old. As a U.S. citizen, you have to be 21 years old to apply for your parents as an immediate relative. Why? The law says so. If your parents entered the U.S. illegally, they might have to leave the U.S. and apply through a U.S. consulate. In that case, your citizenship may not help them, because if they've accumulated more than 180 days in the U.S. unlawfully, they will be barred for 3 or 10 years unless they're approved for a waiver. So if they're in the U.S. without permission, more than 180 days, when they leave the United States, the bar of 3 or 10 years is triggered, and they can't return unless and until a waiver is approved. Now, this waiver would make their unlawful presence in the U.S. forgiven before leaving the country for a consular interview. But hardship to you, the child petitioner, doesn't count for a waiver. They're going to need to show extreme hardship to a qualifying relative if they are deported. Now, qualifying relative is a U.S. citizen or lawful permanent resident, spouse or parent. So they need a qualifying parent or spouse who is also a citizen or lawful permanent resident. It's a tricky area of law. You do best to consult with an attorney before applying for a waiver. So give us a call. Who qualifies as your parent? If you're from a traditional family, that is, you were born and raised by a married couple, you should have no problem petitioning for your parents to immigrate. However, U.S. immigration law also recognizes some variations in the traditional family. Under certain circumstances, you can also petition for unmarried parents, step-parents, or adoptive parents. You'll usually have to provide additional documents to prove the relationship. First, your natural mother. Suppose your mother was not married to your father when you were born, and your mother's maiden name is on your birth certificate. In that case, you can prove your relationship by presenting a copy of the certificate when you file the petition for your mother. At the end of the day, we almost always know who mom is. Dad, not always clear, but mom is almost always clear. If your mother has changed her name because she married someone else, present her marriage certificate to show her change of name. Your natural father. Suppose your biological father did not marry your mother before or even after you were born. In that case, you can still petition for him as your immediate relative. You just need evidence of your relationship. Make a copy of your birth certificate, baptismal certificate, or any other religious records showing his name as your father. USCIS may also require you and your father to take a DNA test to prove your relationship. If you and your father did not live together before you turned 18, you need to prove that up to the time you turned 21, he maintained a father-child relationship with you by providing financial support, communication between you or your mother about your well-being, sending you birthday cards, holiday cards, photographs of you together, his naming you as a beneficiary for his life insurance. Suppose you lived with your father before your 18th birthday. In that case, you must present proof of father-child relationship. as evidenced by school records, photographs, letters, civil records, or written statements from friends and relatives. What about step-parents, stepmom or stepdad? Suppose your father or mother marries somebody other than your biological parent before you turn 18. In that case, the person they marry becomes your stepmother or stepfather. Filing a petition for step-parents is the same as filing for your natural parents, but the marriage must have occurred before you turned 18. You first start with Form I-130, and you'll need to complement it with documents like your birth certificate showing the name of your remarried parent, or marriage certificate of your remarried parent showing your step-parent's name. If the marriage occurred after you turn 18, you could still apply for your natural parent, and after he or she gets their green card, your natural parent can apply for your step-parent, meaning their spouse. Now, this would mean the step-parent would take a second preference beneficiary. That means it's going to take years before they get their visa approved and they get your green card. But it is still doable. It's just not direct. Let's talk about adoptive mother or father. Let's say a non-US citizen let's say you were adopted by a US citizen before you turned 16. If you're a US citizen and now 21 years old or older, you can petition for your adoptive parents as your immediate relatives. Obviously, if they're US citizens, they don't need you to petition for them. So it's only when they're not a US citizen and not a lawful permanent resident, and they adopt you before you turn 16. When you file the petition, you must submit, and again, it's still the I-130, same thing. So you're gonna have to submit court decree of your adoption. Your birth certificate shows the name of your adopting parents as your father and mother, and a certificate showing the dates and places you have lived together. Here's a quick view of the application process. To get a green card for your parents, step-parents, adoptive parents, biological parents, no distinction, we'll just call them a parent. You first start by preparing petition form I-130 with supporting documents proving to the immigration authorities your relationship. And I talked about natural, step, or adopted. The documents differ depending on the type, but at the end of the day, you still need to show that they are your parents under the relative process under the Immigration Naturalization Act. After that petition is approved and a visa is available, your parents will need to change their status. This process proves that they qualify as parents of a US citizen and that they're otherwise eligible for US permanent residence. And it can happen one of two ways: through the adjustment of status, which occurs inside the United States after filing Form I-45 and being interviewed at a local USCIS office. Now, not in every scenario are they going to interview you and your parent. They often do, but it's not obligatory. Consular process. Generally, if their last entry to the US was not lawful, or they are living outside the US now, they have to file Form DS-260 and attend an interview at the US Embassy or Consulate. And they will always get an interview because that's how they get their visa and ultimately get approved for their green card. If you have any questions about filing a green card for your parents, please make sure to leave a comment below, give us a call, or visit our website at undersmecherlaw.com. Book an appointment. We're here to help. Remember, every case is different and we won't take your money if we can't help you. Please consider subscribing to the channel and checking out our other videos if you found this one helpful. If you learned a lot, feel free to like and share it. Until next time, stay healthy and be safe. Hey, did you like the video? I invite you to watch another video where I share more tips on how to protect your reputation as an immigrant. Until next time.